everyone, and welcome to this virtual panel discussion hosted by the Hudson Institute in Washington, D.C. My name is Devlin Hartline, and I'm legal fellow at Hudson's Forum for Intellectual Property. We're here today to talk about an important case at the intersection of the First Amendment and trademark law, Jack Daniels versus VIP products. The Supreme Court is set to hear oral argument in this case tomorrow, March 22nd. And we have three expert panelists with us today, whom I'll introduce in a moment. But first, I want to quickly discuss what's happening in this case. So VIP makes dog toys, and Jack Daniels makes the famous Tennessee whiskey. VIP sells a humorous parody called Bad Spaniels, and the dog toy is shaped like a Jack Daniels bottle with similar colors and fonts, and it includes dog excrement jokes. Jack Daniels claims that the dog toy infringes its trademarks and trade dress, and that it tarnishes its brand. So while on the surface, this case is about a funny dog toy, the Supreme Court's decision will likely have broad implications for free speech and trademark protection. So the court will look at whether the humorous use of another's mark on a commercial product should be analyzed under the traditional likelihood of confusion test, or it should instead receive heightened First Amendment scrutiny under the so-called Rogers test. The Rogers test is applied when the mark is used in an expressive work. And the idea is that the traditional test does not adequately accommodate the public interest in free expression. So the court could simply say that a dog toy is not an expressive work, so Rogers doesn't apply. It could also address the Rogers test directly, perhaps fashioning a different test for expressive works. Or the court could say that the Rogers test is never needed and infringement claims should be analyzed under the traditional multi-factor test. The second issue before the court is Jack Daniels' claim that the dog toy harms its reputation. So this is what trademark lawyers call dilution by tarnishment. And the theory is that VIP's humorous use will lead consumers to associate Jack Daniels with dog excrement. And so the question here is whether Jack Daniels' tarnishment claim is foreclosed by a statutory exception for non-commercial uses. The Ninth Circuit held that VIP's use is non-commercial because it does more than propose a commercial transaction. It conveys a humorous message. So turning back to our discussion today, we have three wonderful expert panelists who have all filed amicus briefs in this case. And reading through the various briefs, it struck me as interesting how varied the arguments are. And so my vision for this panel was to bring together people who are coming at this case from different perspectives. So we'll start with quick introductions from each panelist, hearing about their organization and their interest in the case. We'll then move on to a moderated question and answer discussion. And finally, we'll end with each panelist's closing thoughts on the case. And so let's start with Megan Bannigan. Megan, please introduce yourself.
Hi, thanks, Devlin, and welcome everyone. It's great to be here. I'm Megan Bannigan. I'm a partner in the IP litigation group at Debevoise and Plimpton in New York, where I focus on some of these cutting edge and exciting IP issues. I'm also a professor of trademark law at NYU, and I teach fashion law, which is very related to some of these topics at Rutgers. I have been interested in this case for a long time. Like many of us, we've all been following it since the beginning, and following just the Rogers v. Grimaldi test and the application of the Rogers v. Grimaldi test through the circuits. In this particular case, I represent a cohort of law professors who have put in an amicus brief arguing for a modified Rogers test, and we can talk a little bit more about that. But the goal of these law professors is really to ensure that the First Amendment protections continue, but we're protecting brands and not losing the Lanham Act protections either. So we're looking for a middle ground to protect both artists, and brands.
Wonderful.
And I look
Thank
forward
you.
to discussing. Yeah.
Thank you, Megan. It's great to have you here. Let's next go to Ben Sheffner.
Thanks, Devlin, and thanks to the Hudson Institute for having me. So I'm Ben Sheffner. I'm an attorney with the Motion Picture Association. We are, of course, the trade association that represents the 6 big motion picture and television studios based here in the U.S. That includes Paramount Pictures, Netflix, Sony Pictures, Disney, Warner Brothers, and NBC Universal. So at first, we thought we frankly weren't paying a whole lot of attention to this case. This was a fight between a liquor company and a dog toy maker. Doesn't sound like it has a whole lot to do with movie studios. But as the issues percolated up to the Supreme Court, we realized we have actually 2 big interests in this case. One, our members have a strong interest in creative freedom, and that creative freedom includes the ability to depict the world as it actually exists, including the products and services that people use every day. So we want to make sure to be able to preserve that creative freedom. On the other hand, the other interest is our companies are also major trademark owners. They believe in trademark law. They have consumer products. They do all sorts of marketing. They respect and appreciate trademark law. And they want to make sure that they, just like any other trademark owners, have the ability to prevent others from making knockoff products or otherwise, misappropriating their goodwill in inappropriate ways. So again, although this case involves a liquor company and a dog toy maker, it could have a really direct impact on movie studios, and I'm sure we'll get into a lot more detail about just why that is.
Great. Thanks, Ben. And finally, let's hear from Vijay Toke.
Yeah, thanks so much. And thank you to the Hudson Institute for having us and inviting me to be part of this panel. My name is Vijay Toke, and I'm a partner at Ramon, which is a law firm, an international law firm. I am resident in the San Francisco office. My practice centers on trademark and copyright litigation. Like Megan, I've been involved in this case and following it from the beginning, and it's been going for quite some time. And I represent, in this case, the International Trademark Association, or INTA, or INTA. INTA is one of the largest trade groups of trademark owners. And as Ben said, Ben Sheffner said, our membership really spans a lot of types of companies, all brand owners of all types all over the world, many of which also create content. And so for INTA members, it was important to provide our thoughts to the court with our amicus brief to both balance First Amendment and a heightened First Amendment standard in certain circumstances, and while balancing the rights of trademark owners to enforce their rights against infringers. So that was really our focus, and I know that we'll get a lot more into what INTA's position is and the definition of expressive work that we proffered to the court.
Great. Thanks to all 3 of you for being here. I really appreciate it. And it's an important case, and there's obviously a lot of interest in it. And it's about far more than just a dog toy. So Vijay, I'd like to start with you. And so trademark infringement claims are generally analyzed under this traditional multi-factor likelihood of confusion test. However, when artistically expressive works are at issue, courts will apply heightened First Amendment scrutiny under the so-called Rogers test. And so in this case, the Ninth Circuit held that VIP's dog toy, Bad Spaniels, is an expressive work because it communicates a humorous message. But others argue that the Rogers test should not have been applied to an ordinary commercial product like a dog toy. So how should courts decide whether something is an expressive work?
Yeah, thanks, Devlin. I think first we have to step back. Before I answer that question, I think we step back for a moment and why we're in before the Supreme Court right now. The Supreme Court has never spoken about a heightened First Amendment standard in any circumstances. But Rogers has been around since 1989. So it's at this point longstanding precedent that has been adopted by a number of circuits. Most circuits, I think, as I understand it, any circuit that's considered it has adopted it. And so we now have amongst the circuits somewhat of a consensus that in certain circumstances, a heightened First Amendment protection standard might be appropriate as and using the Rogers test to do that. So the question is, well, in what circumstances? Rogers, of course, was born from the circumstance of a movie title. And the Second Circuit in Rogers made very clear that the reason that it was applying a different standard, in fact, it said, this isn't a Lanham Act case because we're talking about a title of an artistic work. And so from the genesis of the Rogers test was really in that very specific type of context. Since then, Rogers has been adopted and applied in a number of circumstances where there was expression in the work at issue. But in all of them until the Ninth Circuit's expansion of the Rogers test, it was always in the context of an artistic expressive work, something you would traditionally think of as an artistic expressive work. Movies, television shows, art in terms of titles of photographs, etc. The Ninth Circuit has steadily expanded the application of Rogers, and I think this is the culmination. This case is the culmination of that expansion. And for a lot of trademark practitioners, I think, and especially trademark owners, believe that this expansion was crossing the line because it's really, other than an oblique expansion of Rogers to ancillary advertising products in the Empire case, this is really the first case where Rogers was applied to an ordinary commercial product here at Dog Toy, as you mentioned. And so because of that expansion by the Ninth Circuit, we've seen a proliferation of defendants saying, "Oh, yeah, we've got this this product that has expression in it." And the Ninth Circuit defined, or is in this opinion, defined an expressive work as one that has any product that has expression in it, which of course is a very broad definition that is quite different than the genesis of Rogers being a traditionally artistic work and not an ordinary commercial product. So INTA tried to struggle with that and that jurisprudence and trying to figure out, okay, well, what is the appropriate way to address this? Do we address the test itself, as the district court seemed to suggest might be an appropriate change in the final decision before Jack Daniels appealed and now ultimately is before the Supreme Court? Or do we look at the gatekeeping function of what is an expressive work? Because there's certainly other works that may not fit into the traditional movie or art that we've seen Rogers apply to, but might nonetheless still be an intrinsically or inherently expressive work. So that's the avenue that INTA decided to take. And that is to provide a gatekeeping definition of what is an expressive work. So our suggestion to the court, which I noted is unique amongst the amici, many of whom went one way or the other. Obviously, Jack Daniels took the position that there shouldn't be any heightened protection at all. It's not within the language of the Lanham Act, and others who said there shouldn't. Anytime there's expression, there should be heightened First Amendment protection. So we took the middle ground, recognizing that there may be circumstances where heightened protection is appropriate. So we defined an expressive work as one where the expression is inextricable from the product itself. What does that mean? If you abstract out, you take out all of that expression, all of it, all expression whatsoever in that product, do you still have that product? So for example, in a movie, if you take out all the expression in a movie, you're left with nothing but well, it used to be celluloid, but maybe now whatever fixed medium they use to Ben, you would know more than I in terms of how they capture it now. But in any event, you would have nothing. You would have no movie. Similarly, in a piece of art, if you removed all the expression from that piece of art, would you have that piece of art? Probably not. So contrast that to a commercial product like the one here, where you have a dog toy, and if you took all of the expression claimed in that dog toy, you'd still have a functional dog toy. Same thing with a T-shirt, a mug, anything like that, where you could certainly place expression on it, and yet you would have you would still have that functional product even if you took all the expression out of it. And I would note that the reason we came up with this this definition is because it's important to recognize that even under traditional trademark analysis and the likelihood of confusion test, there are robust First Amendment protections built into them already. Concepts like parody and nominative fair use or other commentary are well represented and protected within traditional trademark analysis. We can look to a number of cases that have applied those traditional principles, and the defendant still won. In a lot of times, I say that in these types of parody cases, if the judge laughs, you win. And so that is, I think, something to remember, that it's not as if traditional trademark principles being applied means that there is no First Amendment protection. That's quite the opposite.
Great. Yeah. And so, Ben, correct me if I'm wrong, but the MPA endorsed the test that Vijay had in his brief. Is that correct?
We did. There was a brief section in our brief where we said, look, we actually think that the test that INTA came up with, again, whereas if you strip away all of the expression and you still have a functional product, then you're not in Rogers land. And, we thought through all sorts of hypotheticals and bannered this around, and we think, you know what, that actually makes sense in the analogy that we used. People actually still buy DVDs. It's still a multi-billion-dollar business. So we thought, you know what, if you strip away all the content from a DVD, you still have a coaster. But again, analyze movies under Rogers, please.
And we appreciate the endorsement, by the way, Ben.
Yeah. So, but also what we said in our brief is that, and one reason why we didn't dwell too much on the test is we said, you know what, whatever the test is, a dog toy doesn't meet it. A dog toy is still a far, far from the kind of expressive work that Rogers was intended for and is the appropriate test to apply when there's a trademark claim in the context of an expressive work.
Great. Well, Ben, I want to stay with you and talk about the Rogers test. So the Supreme Court can make broad pronouncements on how trademark law should be applied to artistic works with its decision in this case. But the two parties, as you mentioned earlier, Jack Daniels and VIP Products, they're not really in the business of making artistic work. So one sells spirits and the other sells dog toys, right? But the member companies of the Motion Picture Association, by contrast, they have a direct stake in this litigation because not only do they make artistic works, they're trademark owners themselves. So I was hoping if you could explain, why is the Rogers test so important to the creative industries?
So yes, you're absolutely right. We felt like this was a little bit strange. It was like our fate was going to be decided by a liquor company and a dog toy company. We actually took the fairly unusual step of filing a motion for leave to participate in oral argument. The Supreme Court decided not to grant it. But in our motion, we actually had what I thought was a great line. We said, allowing a dog toy maker and a liquor company to debate this issue is like Hamlet without the prince. And so we were just sitting on the sidelines and said, hey, we really, really care about this. But anyway, to your question, why is Rogers so important to our industry? And we talked about this internally about exactly how to describe it, whether it's the most important sort of case day to day for our industry or one of the most important. I will definitely, no doubt, it's in the top three, let's put it, for the day to day work that lawyers in our industry actually do. And the reason is what we call the clearance process. So this is the process for any movie or TV show that's produced by one of our companies. Is early on, a lawyer will sit down and very carefully go through the script, and they're essentially issue spotting. Is this going to violate somebody's rights? Is it going to violate somebody's copyright? Is it going to invade their privacy? Is it going to violate their right of publicity? And of course, is this going to violate somebody's trademark rights? And as I mentioned before, the writers and producers of shows, they often want to depict the world as it really is, and that's a world where people drink Coke, where they use iPhones, where they drink a Jack and Coke, where they sit around bantering about how McDonald's sells a Royale with cheese in Europe. And when they do that, the analysis of, well, are we going to get sued by one of those companies for trademark infringement? Rogers is a huge help. It's a relatively clear, relatively simple type of analysis to determine whether one of those companies is going to have a legitimate trademark claim in that circumstance. Certainly, the analysis is much, much easier and more straightforward than you would have if you had to apply a complicated 8-factor likelihood of confusion balancing tests, like the Polaroid factors, or in the Ninth Circuit, we have the sleek crack factors, etc. And the problem with applying the traditional likelihood of confusion test is that it's less predictable. And that, if we guess wrong here, or if we have a really aggressive trademark owner who's going to bring a claim, that could be years of very expensive and burdensome litigation. There's going to be, consumer surveys about whether they're confused about various things. Cost millions of dollars and potentially years litigating that through summary judgment or even trial. And what that would do is it would cause the studio to be more cautious and say, if something is closer to the line, we'll just use a generic product, or we won't mention it at all. And frankly, that's an inhibition on creative freedom. And there's a term for this in First Amendment law. It's called the chilling effect. And one theme of our brief that we filed in this case is that if you didn't have Rogers, and instead you had to apply the traditional likelihood of confusion factors when evaluating whether you can depict or refer to a trademark product or service in a movie or TV show, again, that would chill creative freedom. And that's not appropriate in a world where, yes, the First Amendment is going to be an overlay over any of those types of potential claims that I mentioned a few minutes ago.
Yeah, and well, first of all, I appreciate the Pulp Fiction reference, so thank you for that. But I think what you're saying is so important, because it's not just the free speech interest of the other side. It's right that the mark owner, these motion picture studios, obviously have their own First Amendment interest in producing these creative works. And so the trick is trying to balance these things. And I'll also just add, we talk about the traditional multi-factor test, but the reality is that I think every single circuit has a different test. So there's 12 different tests depending on which circuit you're in. And one thing that, at least from my perspective, unfortunately, we probably won't get in this case, is the court saying, okay, here's the test for infringement. So no. But I do want to continue with Rogers, and Megan, I'd love to hear from you. And so, as we've been discussing, under the Rogers test, there's heightened scrutiny. So the court requires the plaintiff, usually the mark owner, to show that the defendant's use of the mark it's either not artistically relevant to the underlying work, or it explicitly misleads consumers as to the source of the work. And so, applying that test in this case, the district court held that Jack Daniels could not establish either element. And so that means VIP's dog toy is protected by the First Amendment. And so we don't have to do the regular infringement test. But, reading your brief, I saw you actually proposed a way that the Rogers test could be improved to better balance the public interest in free expression with the public interest in avoiding consumer confusion. So could you discuss how the Rogers test could be improved?
Yeah, absolutely. I mean, there is just so much at stake in this case. It's really, as my co-panelists and you have already said, it's, how are we going to balance these First Amendment interests against trademark rights? And it's just an absolutely crucial question for both artists and for brand owners alike. And I love that both Ben and Vijay are here, arguing for brands and arguing for the artists. There are obviously so many ways that the courts could go, but the best approach to me is let's preserve Rogers. Let's keep this recognition that the likelihood of confusion factors, whatever they are, depending on what district you're in, they're not quite enough to get to these paramount First Amendment issues. And so the amicus brief that I filed on behalf of the IP professors advocates, we need to modify this. As Ben said, the test is not entirely clear. Well, he was talking about likelihood of confusion, but even that's clear for Rogers as well. The test can be vague. It's not only do we have different likelihood of confusion factors applying in different circuits, but we have different circuits applying the test very differently. And that has led to unpredictability for both brands and artists. And so at the very least, we need clarification, but modifications would be even better. So one potential modification that we advocate for is to create a presumption that Lanham Act liability is precluded when a work is found to be an expressive work subject to the First Amendment. So in other words, what I mean by that is in order to fully protect artistic interests, we'd actually advocate for placing a presumption that artistic works cannot be subject to trademark infringement liability unless the brand owner can show that there's a reason that the standard likelihood of confusion factors should apply instead. And that's the big point there. And there is a reason that those regular factors should apply. That's where the second potential modification comes in. We think that it would help to, let's just replace the artistic relevance prong of Rogers, which really calls on courts to take the role of art critics. And that can't be what was intended. And so what we would do is replace that with a clear gratuitousness prong. So rather than placing a burden on an artist to show that its use is relevant to expression and to having the court judge if it really is relevant, the burden instead would be on the brand owner to show that the defendant's use is clearly gratuitous. And so what does that mean? It means that the use is merely free riding on a plaintiff's goodwill. And so we believe this approach would protect valuable commentary on or criticism of a brand or a brand owner, for instance, through parody. It would protect artistic representations of the world. For instance, if you're accurately showing branded storefronts in a film. And it would also protect the titles that flow naturally from a work's subject matter. For instance, the title of Ginger and Fred, that was the issue in the Rogers test that started it all. And so it would give those protections, but at the same time, weighing toward protection of the public from confusion, where a defendant is clearly just using a brand's trademark to promote or sell its goods. One other important clarification, and I don't actually think this is necessary on the face of Rogers, but there have been some questions about it. And so it should be clarified once and for all. And that would be to show that Rogers is actually medium neutral. And what does that mean? That means we can't say, this is traditional art, so this should be protected, but this is untraditional art, so this shouldn't get as much protection. That's not what the First Amendment calls for. Artists should be free to use whatever medium they want to express their ideas, whether that's a sneaker, that's a dog toy, or something else. But what's important is there actually has to be ideas expressed here, and it can't just be the idea I'm expressing is, oh, maybe someone will think of Jack Daniels and buy my product. We believe this is consistent with the court's First Amendment jurisprudence, the progression of modern art, where our artists are obviously using different mediums to express their ideas. So when you look at all of this in the context of the Jack Daniels case and the VIP products case, Rogers could, under this modified approach, in theory, apply to a dog toy, but it would apply only if the jokes had a purpose other than merely to promote the sale of a dog toy. There'd have to be some kind of comment on Jack Daniels or some kind of promotion of an artistic message beyond drawing a humorous association between the toy and Jack Daniels.
Yeah, that's very interesting. I don't know, do the other panelists have any thoughts on this proposed change to the Rogers test, at least from the perspective of the brand owners or studios?
Yeah. So I think INTA's brief didn't take a position on the Rogers test itself. We just recognize that there may be circumstances where a heightened First Amendment protection might be appropriate. INTA leaves to the court to either adopt Rogers or modify it as Megan's clients suggest, or to fashion its own test. But I just wanted to say that I think that our definition of what is an expressive work is not necessarily mutually exclusive with the modifications to the Rogers test that the professors suggest. Because again, this gatekeeping function is helpful because it is difficult in certain circumstances to decide, well, is this joke really meant as a joke, or is it really meant to be promoting the product to create the association with the brand owner so that the person makes the purchase? And so by creating a definition that is a better gatekeeper of what is an expressive work in a world where artists do use more and more media, then that definition will allow the capture of 95, 99% of cases to make sure that the appropriate test is applied. But as to the modifications of the Rogers test itself, we'll have to see what the court does. But INTA was somewhat neutral on that.
Yeah, I would just say, to pick up Vijay's point, there needs to be a gatekeeper. There needs to be some sort of real definition of what is an expressive work, so that you would apply Rogers, and what is not an expressive work, and then you're back in regular likelihood of confusion territory. And I think, what the Ninth Circuit did in this case, and this is where we agree with Jack Daniels, although we vehemently disagree with them that Rogers should be wiped off the books. We agree with them that the Ninth Circuit went too far. So you have this situation, which I think is common in lots of different areas of the law, where you have a bucket that gets you let's call it favorable treatment. So if you are a defendant in a trademark case, you would like Rogers to apply because it's more favorable to you than having the likelihood of confusion factors apply. So that creates this incentive that every trademark defendant wants to jump into the Rogers box. And you're going to have all sorts of defendants who say, oh, my product, yes, I'm selling this kind of widget, but I have a message on there too. And at some point, the courts have to step in and say no. And I think, again, the Ninth Circuit's rule essentially that if you have any sort of humorous message on your product, you are then in Rogers territory, is just it's a bridge too far, and it's really going to harm the legitimate interests of trademark law in preventing consumer confusion and protecting the goodwill of the trademark owner. Again, we think that the INTA test that Vijay and his colleagues came up with works pretty well. I'm not sure how different the result would be in the test that Megan advocates for in her brief. But again, there needs to be a real test that separates out true expressive works from, let's call them, fairly opportunistic attempts by purveyors of consumer products, legitimate consumer products, where they slap on some sort of humorous message to take advantage of this test that they consider advantageous.
Yeah, well, Ben, I want to stay with you and on the Rogers test. And so there are some people out there that argue that Rogers goes too far And just to be clear, the MPA didn't argue this, but some people do. And so here's the issue. So under the Lanham Act, the test is whether the use is likely to cause confusion. And in this case, we see the concern. So the district court originally held that VIP's use was likely to cause confusion and thus infringing. But then the Ninth Circuit said, oh, no, you should have applied the Rogers test. So on remand, applying the Rogers test, the district court held that it wasn't infringing. And so the district court lamented in the opinion that this explicitly misleading test prong of Rogers is unconcerned with the real world effects on a senior user's mark. And so is this really a problem under the Rogers test that some uses that are likely to confuse are going to be protected by the First Amendment?
I don't think so if Rogers applied in the right way. And again, we don't think that the Ninth Circuit applied it in the right way. It expanded what counts as an expressive work, I think, beyond the breaking point. And again, on that point, we agree with Jack Daniels. I should point out that, and I think Vijay alluded to this before, just because Rogers doesn't apply doesn't mean that there aren't legitimate defenses. There are all sorts of defenses. There's parody and satire defenses. There's the defense that you're not using it in a trademark use sense as a source identifier. There's the nominative fair use doctrine. So I think it's important to keep in mind that, again, just because you're not applying Rogers doesn't mean that the defendant automatically loses. Again, going back to the original Rogers versus Grimaldi test, it was about titles, not the body of works. But what the court said, and I think this is absolutely right, is that a title of a movie has dual functions. It's partly a source identifier, but it's also partly a creative work or an element of a creative work in and of itself. And the test that the Second Circuit came up with, which again is from 1989, and I think has really stood the test of time, was intended to balance those two things. And essentially, it's a rule of construction that allows the Lanham Act to be applied in the context of expressive works without infringing on important First Amendment rights.
Great. And so I want to continue that thread about that. Even if Rogers doesn't apply, that doesn't mean it's infringing. And so, Megan, I'll direct this to you. So if the defendant's parodic use doesn't qualify as an expressive work that gets heightened First Amendment scrutiny under the Rogers test, it's not necessarily infringing. All it means is now we're going to do a regular multi-factor likelihood of confusion test under the Lanham Act. But doing this test, the courts will take the fact that it's a parodic humorous use into account. So how do courts approach this when it's a humorous use?
Yeah, that's a great question. And before I answer it, the one thing I want to point out there is the timing. And the timing, it shouldn't be, and it actually, it just shouldn't be that you're only looking at the likelihood of confusion factors if you have found that this First Amendment offense, whatever it is, whatever the court decides it is, if it exists at all, applies. Actually, there are two distinct things we're dealing with. We're dealing with a parody defense under trademark law, and that's what we're talking about if the First Amendment doesn't apply. These are just a simple variation of the no likelihood of confusion defense. And so it's not an affirmative defense to a charge of trademark infringement, but instead you say, this is a parody. And that's a way of arguing that because it's a parody, there will be no trademark infringement because there's going to be no likelihood of confusion. And the parodist is arguing that an ordinary viewer is going to get the parody. It's a successful parody, and the viewer is never going to be deceived or confused. Now, this is obviously the test you are getting at with your questions. But what I want everyone to recognize is that there are many, many, many times that one of these cases can be dealt with at the outset just by applying these likelihood of confusion factors, and you never have to get into the First Amendment defense at all. And that's actually the simpler way to do it. If you can look at the likelihood of confusion factors, and there are some slight adjustments that courts apply when there's a parody, and I'll give you a few examples in a minute. But if you can look and just apply the likelihood of confusion factors without having to change the test, find that there's no confusion, and the analysis can end there, and we don't need to implicate the Constitution. It really, I feel strongly we should only implicate the Constitution with this First Amendment parody defense if we have to. And if you look at examples, courts regularly find that no likelihood of confusion exists when you're dealing with parodies. And that was, of course, some of the most talked about cases is the Louis Vuitton v. My Other Bag case. Similarly, the Louis Vuitton, the hot diggity dog case in the Fourth Circuit. So, it can certainly happen. Now, there are adjustments to the likelihood of confusion factors. Those are necessary. Like, for example, regardless of what circuit you're in, you look at the degree of similarity of the marks when you're dealing with a trademark confusion analysis. Obviously, under the standard situation, very similar marks lean more towards confusion. But here, in order for a parody to be a parody, the parody obviously must reference the other party's mark. So the degree of similarity factor, for example, weighs less heavily in the case of a parody. The other example I'll mention now is the strength of the mark. And so obviously in a typical likelihood of confusion analysis, the stronger the mark, the stronger the likelihood of confusion. But it's actually opposite when you're dealing with a parody, because courts recognize that the stronger the plaintiff's trademark, the less likely consumers are to be confused by the parody. And that's because the strength and the recognizability of the mark make it easier for the audience to realize that this is in fact a parody and a joke. So, there are some similar tweaks that we make to the factors, but there are plenty of times that we can apply these factors and find no confusion and just move on from there.
Yeah, no, that's great. So Vijay, I think you have something to add here.
Yeah, I was just going to say, I agree, of course, completely with Megan's remarks on this, but that courts will look at if you can avoid going to constitutional principles. Absolutely, that's the better way to go. If a likelihood of confusion analysis will address it, but talking about the My Other Bag case, the Louis Vuitton case, and when dealing with parody, courts will look at how effective was that parody? Because as they noted in My Other Bag, the Second Circuit said a parody must convey two simultaneous and contradictory messages: that it is the original, but also that it is the original, that it is not the original, and it instead is a parody. And so I think courts will look at that. I guess that goes back to my adage of if you make the judge laugh, you win. That's just distilled that same principle. But I think that's really what courts will look at. And as a result, there are, I think, significant First Amendment protections already built into a traditional trademark analysis.
Yeah, absolutely. So even if we're not in Rogers land and we're doing traditional analysis, the fact that it's a parody or a humorous use will put the thumb on the scale pretty heavily towards it being non-infringing, right? Like Megan said, normally a strong mark gets a lot of protection, but when it's parody, it's kind of reversed. And they say, well, the stronger the mark, the more likely it is that people will get the parody and that it will be parodied by other people. But I will just note that in this case, we actually have the district court did the analysis under the traditional test and taking into account that that VIP's use is parodic, and it still found that it was likely to be confusing. The Ninth Circuit didn't address that holding because it said you did it wrong. You should have applied Rogers. So it's possible down the road on remand we'll actually get the Ninth Circuit looking at the district court's application of the multi-factor test in this case. So it'll be interesting to see if the Ninth Circuit agrees. And so Vijay, I want to stay with you. So yours was the only brief among all three of you that addressed the dilution argument. And so Jack Daniel's claims that VIP's use tarnishes its brand because consumers will associate the Jack Daniel's whiskey with excrement. And so the district court agreed, but the Ninth Circuit reversed. And so it held that VIP's use is non-commercial, and thus under the statute, it's exempt from dilution liability. Curiously, the Ninth Circuit did not apply a separate statutory exception for parodies, even though it seems like that would have been a better fit under the facts. And so how do you think the Supreme Court should approach Jack Daniels's dilution by tarnishment claim?
Sorry, I agree with you. I think that our view is the Ninth Circuit should have applied the parody exception that is built into the dilution statute under Section 1125C3A. It didn't do that. I would again note that in the My Other Bag case, that was addressed. The court did look at it, and the Second Circuit considered, all right, well, does this exception apply? And one notable part about that exception is it's not available where the defendant uses the mark as a source identifier. And so that is an important part that's an exception to the exception, if you will, built into that section of Section 1125 of the dilution statute. The Ninth Circuit didn't do that. Instead, it gave very short shrift to the dilution issue. I think it was a couple of paragraphs at most, and just simply said, "Oh, this is an expressive work, therefore it's non-commercial, and there's no dilution because it's not available." So we think that if the court first, I think the Ninth Circuit should have applied the exception, or at least analyze the exception under the dilution statute. But if it was going to go the non-commercial route and analyze whether or not this was a non-commercial use, then the court should have applied the Supreme Court standards under Central Hudson and determined whether or not this was a non-commercial use. The Ninth Circuit didn't do that. And so INTA's position is that the court should have done it, and the Supreme Court should clarify that in these types of circumstances where you have a claimed expression on a product, that the test already exists, and the Ninth Circuit erred by not applying that test.
Yeah, and I just want to add, Devlin, I'm going to sort of sidestep the question about kind of the intricacies of the dilution statute, but I think your question about Jack Daniel's interest in sort of not being associated with dog poop gets into what for us is the really important issue in this case. Obviously, I understand why Jack Daniel's does not want to be associated with dog poop. No brand does. But this gets to this issue of creative freedom. So look, if the hero in a movie is drinking Jack Daniel's is going to be either neutral or positive about that. Who knows? They might even pay for it in a practice that people know as product placement. But the problem arises when the portrayal of a product or service is maybe not so positive, or maybe the villain is drinking Jack Daniel's. We cited in our brief the example of a movie several years ago called Flight, starring Denzel Washington as an airline pilot who also was an alcoholic. And that movie depicted him drinking several real brands of alcoholic beverages. And our brief says that was not done with the permission of those brands. And our position, as far as I'm aware, there was never any legal claims about any of those uses. But our position would absolutely be that the studio has the First Amendment right to do that, even if, from the perspective of those brand owners, I am absolutely certain they were not happy about having their brand associated with an alcoholic airline pilot.
Yeah, well, and it reminds me of what the Supreme Court said in Campbell, on, like there was a parody there in a copyright case. And they said, well, market harm doesn't include like harm to reputation, like people might think differently of Roy Orbison because of Tulay Cruz cover of the song, right? So that kind of harm is not actionable. That's not what we're worried about. So one interesting thing I'll say on this dilution issue is that, reading some briefs in support of VIP is, so there was another IP professor's brief, and it argues that the dilution by tarnishment statute itself is unconstitutional. And so we've seen the Supreme Court strike down like the bar against registering disparaging marks as being viewpoint discrimination. And so I don't think that this case is a good vehicle because the parties didn't really brief it. But at the back of their mind, when they're analyzing dilution, I think they might be thinking, about the constitutionality of the statute itself. So it'll be interesting to see. I think it's pretty clear that the Ninth Circuit applied the wrong exception. They should have looked at whether this is a parody. And then that gets into the question of whether VIP is using Bad Spaniels as a mark. So they say, no, our mark is Silly Squeakers. Bad Spaniels isn't our mark. But Jack Daniels has some good arguments for why that's maybe not so. So I do think maybe we'll get into that, whether it's a mark or not. But I don't think we'll get into these constitutional issues, at least not in this case. But I predict in the near future, we will get a case that directly presents the constitutionality of tarnishment itself. And so we're at the end of our time, and I just wanted to give everybody a chance to quickly chime in and express what they hope will happen in this case. And so the argument hasn't happened yet, so we don't really have any indication of what the Supreme Court is thinking. But let's go around and Vijay, we'll start with you. So what do you hope to see happen here?
Well, I hope to see that the court probes the types of circumstances where some heightened First Amendment protection might be appropriate. Again, I know that the statute doesn't have any language in it that might suggest such a heightened test or heightened protections being available. We noted, of course, in our brief that, well, neither is there any language about the multi-factor tests, but those are pretty long-standing and settled law. So just because that language doesn't exist in the Lanham Act doesn't mean that there aren't circumstances where First Amendment protections should be heightened. So I hope we'll see some questions about that. And of course, obviously, with our brief and providing a definition of what qualifies as an expressive work for that heightened protection, I hope that the court will hone in on that and ask questions about the genesis of Rogers and why that's appropriate and what types of circumstances would be the right circumstances to apply this heightened standard. So I'm hoping we'll see some questioning on that, because otherwise you have these two very extremes of no heightened protection whatsoever or heightened protection everywhere where there's any expression claimed. So I hope that the court will probe that middle ground, which I think will really protect and better balance both First Amendment as well as trademark rights.
Great. Ben, let's turn to you. What do you hope to see?
So our number one hope is that the Supreme Court preserves Rogers and says that it or some close version of it is indeed the law of the land. We think it's worked very well for the last 34 years now, and we hope that the Supreme Court preserves it. But we also agree with Jack Daniels that it needs to be cabined to true expressive works. Again, the test sort of loses all meaning if it can be applied to any consumer product that happens to include any sort of message, humorous or otherwise.
Great. And Megan, let's hear from you. What do you hope to happen?
Well, so along similar lines, I obviously hope that the court truly comes up with a test that will balance these important issues. I think all of us might agree that Bad Spaniels itself isn't the obvious vehicle for protecting these First Amendment issues. but look, this is where we are. And the way the court decides this case is going to directly impact the scope of other artists and parodists to reference brands in their work. It obviously impacts brands because, while brands, especially the most prominent brands, they can't escape references in modern culture, whether it's paintings, TV shows, or some other art, they absolutely should be protected from these clearly gratuitous uses where a brand is simply comparing them to dog poop for no other reason than to sell products. And so we think our test makes these modifications to fairly balance these issues. And it gets us there in a way that doesn't restrict artistic freedoms by telling artists, what mediums they can use and what mediums they can't. A brand might not necessarily be able to keep itself from ever dealing with references to these unpleasant topics. But there really is a way that the court can take all of these interests into account and balance all of them in a way that doesn't restrict free speech. So I'm watching closely, and I have my fingers crossed that this is what we're going to see.
I think all four of us will be watching really closely.
I think a lot of us will be watching really closely. Yeah, exactly.
Absolutely. It's hard to exaggerate how important this case really is to trademark law and free speech. So on behalf of the Hudson Institute's Forum for Intellectual Property, I just want to thank all three of you for being here today. I know you're super busy, and I appreciate you taking time out of your schedule to talk about this case that obviously means a lot to all three of you. So again, thank you for joining us, and I can't wait to see what happens. And with that, I'll sign off and say goodbye.